the case of France, Regional France, I was lead counsel. My wife, Ghartey, supported me, being my junior at the bar. And the person who spoke for us, or who was speaking in court, is the current Attorney General. It was in 2012. And our entire argument was that Article 296C said that if you are exercising discretionary power, it should be governed by a constitutional instrument. The Attorney General at the time was my classmate and very good friend, Ben Kumbo, a man who was his campaign manager when he university. He opposed me firmly and won the case. If he had not opposed me, like what she's saying would not happen. Like the Electoral Commission will be governed by specific rules which are contained in the constitutional instrument. So if the Electoral Commission later on decided that it was going to review its numbers, we could have asked the Electoral Commissioner that under what LI or under what CI were you acting. So it's important in all these matters at all times, and I know she won the Attorney General at the time, to realize that some of the actions we take can come back and haunt us. Because I remember that case very well. And indeed, even though the Chief Justice gave us a court and so on, by the time we finished the case, I felt as if the Chief Justice had set us up for losing. Because we lost every single application and lost the case as well. That is what she didn't tell me. So the Chief Justice just gave us the opportunity, but the courts were not moved by the fact that we were making an application. They were not moved by the agency of the matter. They were moved in their view by what they perceived was the law. And I disagree with the court up to date, because I think that the effect of that decision is to declare Article 296C unconstitutional. For the court to say that we cannot implement it because it will lead to a nuclear meltdown, that is not the duty of the courts in my respectful view. They have the power to declare an act of parliament as unconstitutional, but they don't have the power to declare a provision of the constitution as unconstitutional. But please, I was lead counsel in that matter. If I start talking, I may never end. So let me leave it there. Marita, that's my little jab at you, and let me continue. When I was Attorney General, I introduced a rule that every Attorney General should have his picture in the Attorney General's office. I copied it from the Ministry of Interior, the Ministry of Local Government. But I didn't leave my picture. I used everybody's picture. But when I left, about 3 Attorney Generals tried to convince me to bring my picture. I refused. I didn't. But when my fair lady said I should bring my picture, I had to bring it. She's my dear friend and with whom I'm well pleased. So when she tells me to do something, I do it. But I thank the organizers for giving me this opportunity to reflect as a guest speaker on this all-important topic. Our democracy, the constitution, elections, and the judiciary. Our democracy. Just saying this brings me joy, great joy to my heart, because I was born after independence, during the Kwame Nkrumah era, but I don't remember the Kwame Nkrumah era. Dr. Afrajan is laughing at me. Dr. Afrajan, I was speaking the truth. I don't remember the Kwame Nkrumah era. But what I remember is from General Kutu Achampon. I remember that era. During that era, an attempt to impose a dictatorship, couched as union government, was fiercely resisted by, amongst others, Dr. Yahu Tamaklo sitting here, I believe. They formed what they call the Movement for Freedom and Justice. And I recollect as a teenager in Francis School in Cape Coast, we were warned by the headmaster that the Movement of Freedom and Justice were coming to Lawyer Bodiman's house near our school, but we should not go there. Come to think about it, maybe it was rather notice to us that we should go, because as soon as we heard they were there, everybody left the school and rushed to Lawyer Bodiman's house to see the great men of that time. Of course, one of them is sitting with us, and I want you to applaud him. That's Dr. Yahu. Others who were there that day was Okotechi Akwesi Afrifa, Mr. G. W. Amatofio, who was known as Mr. No. Nana Akufo-Addo, the present president as well, was also present. Even in that era, during military rule, Ifansin continued to sow seeds of democracy in his students by setting aside a week or two for what we described as mock parliament. During this period, students were allowed to form political parties, and elections were held, and the head of state, a student, was elected. One political party that I remember was the Junior Students' Party, which was an audacious but failed attempt by we, the juniors, to democratically take over the school for a period. This was a yearly affair, but unfortunately, almost every event, every year, was characterized by a military takeover by unscrupulous students, and this would bring the whole process to an end, and a return to undemocratic rule or the dictatorship of the headmaster and his staff. They'll come and announce that we don't understand what we are doing. They've taken over. They've stopped the mock parliaments. The seed of democracy which was sown in some of us in infancy continued to germinate and grow. And in the university, my natural inclination was to oppose the military regime of the Provincial National Defense Council. I did not need persuasion to actively participate in any activity which opposed military rule and promoted a return to constitutional democracy. So when the AFRC was formed, I supported them because the AFRC was preaching a return to constitutional democracy. As a young lawyer, my desire to see Ghana return to a constitutional elected government did not diminish in any way. I was part of the formation of the New Patriotic Party, even though I was not a signatory to the incorporation documents which made a person a founding member. I was also part of the team that wrote the stolen verdict, which was written by the New Patriotic Party after the 1992 general election. Since then, I've been actively involved in the politics of Ghana as a foot soldier from 1992 to 2005, as a member of parliament from 2005 to date, as a deputy minister from 2005 to 2006, as a cabinet minister from 2006 to 2009, and 2017 to 2021, and as a deputy speaker of parliament from 2013 to 2017. These experiences have increased my belief in democracy as the best form of government. I've lived in an era where there was a culture and silence and a muzzled press. Today, what we have is not perfect, but it is much better than the era where a few men, be they liberators, redeemers, revolutionaries or provisional, as the military men described themselves, concentrated final legislative and executive power in themselves, and also supervisory judicial power to the extent that they had the unfettered right to dismiss judges as they deem fit. It is against this background, and in this context, that I proceed to discuss some aspects of the topic, our democracy, the Constitution, elections, and the judiciary. The Constitution. There are some who preach Armageddon if the 1992 Constitution is not reviewed, and hold the view that the survival of the 1992 Constitution hinges on its total review. I beg to differ. And let me use this occasion to emphasize and re-emphasize my confidence in our Constitution. However, permit me to quote the famous speech of Sowa JSC, as he then was, in the celebrated case of Tufo and the Attorney General, when he said, "A written constitution such as ours is not an ordinary act of parliament. It embodies the will of the people. It also mirrors their history. Account, therefore, needs to be taken of it as a landmark in the people's search for progress. It contains within it its aspirations and their hopes for a better and fuller life. The Constitution has its letter of the law. Equally, the Constitution has its spirit. It is not the fountainhead for authority. It is the fountainhead for authority for each of the three arms of government. It is the source of their strength." He goes on to say, its language must be considered as if it was a living organism, capable of growth and development. Indeed, it is a living organism capable of growth and development, as the body politic of Ghana itself is capable of growth and development. Quotation end. Mr. Moderator, with these hollow words of Sowa JSC, were in respect of the 1979 Constitution. They hold true for the 1992 Constitution to my humble view. This being the case, we should hasten slowly on our quest to totally review the Constitution. Some thinking here and there is not what I'm against. A wholesale review is what I oppose vehemently. The 1992 Constitution itself recognizes that a review is possible, and constantly it has been reviewed once. This was by the Constitution of Ghana, Republic of Ghana, Amendment Act 1996, Act 527. This amendment amended, among other things, provisions on citizenship and provisions on public officers. It allowed for dual citizenship and allowed for public officers to work after the previous mandatory retirement age of 60. With regards to dual citizenship, as a student of investment law, it is my view that it is one of the best things that happened to Ghana in our quest for building a corporate Ghana, which should include Ghanaians in Ghana as well as Ghanaians of Ghanaian descent in the diaspora. As far as the retirement age is concerned, having already attained the ripe old age of 60, I'll say that I agree with the framers of the Constitution, because I want to assure you that I'm as strong as an ox and as fit as a fiddle, and I can continue working even though I've attained the age of 60. Our Constitution is a living document and is growing, albeit as a Constitution, it's still very much in its infant stages. For example, with regards to the question of the separation of power, the Council of State and local government, these are areas that we can look at if we decide to embark on some review of the Constitution. But with regard to the separation of powers, it's a well-flogged horse. And the argument is that the executive being chosen for the legislature offends against the doctrine of separation of powers. The proponents of that view call for a strict separation of powers, where the executive, the legislature, and the judiciary are separate and distinct arms of government. This doctrine of separation of powers, which was first properly formulated by the French philosopher Montesquieu, was formulated to check the abuse of power and to protect the individual from such abuse. The rigidity and purity of the doctrine of separation of powers is no longer the case, and various arrangements have been formulated to ensure that the power of state is kept in check. For example, in Ghana, the Constitution established Commission on Human Rights and Administrative Justice is mandated by Article 218A to, among other things, investigate complaints of violations of fundamental human rights, injustice, corruption, abuse of power, and unfair treatment of any person by a public officer in the exercise of his official duties. Article 33(1) also gives any person the right to seek redress in the High Court where the person alleges that a provision of the Constitution on fundamental human rights and freedoms has been, or is being, or is likely to be contravened in relation to him. That person may apply to the High Court in such situations for redress. These are but two examples of provisions of the Constitution that provide checks and balances to ensure that the individual's rights are not abused by the state. An argument for the strict division of executive and legislative power contradicts or is in variance with those who advocate for what they call the Westminster type of government, where all the members of the executive are part of the legislature. In fact, the former Prime Minister, David Cameron, was made a member of the House of Lords so that he could sit in cabinet. So now he's Lord Cameron. Today, we have a situation in our Constitution where some ministers are members of Parliament. In 1969, we practiced what was called the Westminster form of government. In 1979, we practiced what was called the Republican form of government. And all of us know what happened in 1979, which led to the overthrow of the government. So today, we are practicing a combination of both. It is based on our history. Let us tread cautiously and with caution, and don't let us be in a rush to torpedo our current constitutional arrangement. With regard to the Constitution, the Council of State, admittedly, the full impact of the Council of State is yet to be felt by a body politic. However, I do not think that the answer is to let the Council of State publish its advice as a general rule, as has been argued by some. Indeed, I'm of the view, respectfully, that the framers of the Constitution envisioned the Council of State as a form of advisory council in the nature of the elders who give advice to the chief or head of family under customary law. The advice of the elders or subjects is not made public, and so should it be with the Council of State, if we decide to keep it. As I said before, they are part of the 1992 Constitution, which we can look at as potential areas for amendment. The provisions on the Constitution on local government, in my view, leaves much to be desired. Article 53(3) of the 1992 Constitution restricts the right of political parties to be involved in judicial assemblies or local government units. After the recent judicial assembly elections, supporters of the two major political parties claimed victory, that they had won the election. How can you claim victory in an election you did not take part in? Mr. Moderator, the color scheme of the posters of the various candidates will tell you what party they belong to. Drive to every community. Those who are using red and blue are NPP. Those who are using green and red are NDC. And in fact, they feel proud to go around and tell the NPP people or the NDC people that I am representing NDC or NPP. Whether or not they have the blessing of the parties to do that is another issue. But the most curious thing for me was that after the election, on social media, NPP said they had won 50-something%. Then NDC said it's not true, we won 50-something. And none of the political parties came out to deny it. And nobody can convince me that they didn't see it. Mr. Speaker, sorry, Mr. Moderator. After 20 years in Parliament, Mr. Speaker is all we remember, unfortunately. We must look as elected members of the district assemblies, unit committees, and the chief executives on a partisan basis. And also the funding of our representatives at the local level must be examined. But I must say that members of parliament are not given funds for development. The district assembly common fund is allocated to the districts. The signatories to that account are the district chief executive and the district TFO. And all the member of parliament can do is to request that the funds that have been made available are used for a particular project, and they can refuse it. If they think that what you've asked for is not something that they want to do, it's not in line with their project, or it's not, they can refuse it. And there have been cases of refusal. And in fact, these funds, and when they give you 60,000 for four months, they allocate you 60,000 for 4 months. And as Dr. Farajan said, it comes about 3/4 late. I mean, and it's important that it is said so that the public does not think that members of parliament indeed are giving some money in their pockets. But I agree, we must see how we will fund assembly members for them to perform their duties. But all said, and also, before I forget, any review of the local governance system should look at the role of the chiefs in the governance at the local level. Indeed, there are studies that show that about 60% of the populace listen to their chiefs more than anybody else. When a chief summons you in a village for not doing this or doing that, you go to him shaking like a leaf. And in fact, to exclude them from governance, perhaps it's one of the dilemmas of this constitution. Perhaps it started from the Nkrumah era, where I understand that Nkrumah said, you let chiefs run away and leave their sandals. From that era to now, chiefs haven't gotten their sandals back. I am saying that we should give chiefs back their sandals. They should be part of the local governance setup. Mr. Moderator, all said and done, I'm of the respectful view that the Constitution has served us well. In fact, between 1992 and 2015, poverty in Ghana was more than halved. Between 2015 and 2022, research shows that poverty levels have been fluctuating. The reasons are varied, and corruption is one of the reasons for poverty, but not the only reason. The 1992 Constitution has allowed the sun to shine on all aspects of governance and public life, and public officers are increasingly under the spotlight. Generally, the independent constitutional bodies and key institutions are being called upon all the time to improve their standards by the citizen. Democracy is deepening every day, and we are in a much better place in our understanding of the democracy than when we started our democratic journey in earnest on 7 January 1993 with the coming into force of the 1992 Constitution. Elections and the judiciary. General elections have been held since 1992. After election, we as the people have taken steps to improve the conduct of our elections through consultations such as IPAC, which has resulted in the Electoral Commissioner improving his performance year on year out. Can you imagine the time that ballot boxes were not transparent? And there was the accusation that ballot boxes, real or perceived, that ballot boxes were being stuffed before the election. Today, ballot boxes are transparent. And before the beginning of every election, you are not only shown the transparent ballot box, it's turned upside down for you to see that there's nothing in it. We have spent a lot of time concentrating on the election process itself. But Dr. Farajan talks about what he calls the external factors. And I think it's about time that we spend some time looking at the external factors. For example, what he talks about the judicialization of elections. What he talks about candidates who are unsatisfied with the results going and also it was talked about by the last speaker, rushing to court in order to keep themselves in the limelight or in order to please their financiers. I'm of the considered view that much as we do not intend to stifle the right to go to court, when you go to court and you have absolutely no basis for going to court, you must suffer the consequences. It is now being taken as public interest litigation, so the courts hesitate to impose heavy and punitive costs. But if it can be shown that Mr. A knew or should have known that you have lost the election, in spite of that, you go to court. The court should mulct you with heavy and punitive costs. Because if you are not careful, what will happen is that going to court will become another level of election in Ghana. The minute you lose, you go to court. And then you can tell the financiers that I'm in court, it will be okay, knowing that it will not be okay. I'm not saying that anybody has done that, but I'm just saying that we must be careful. But if you have a reason to go to court, by all means go to court. And I'm telling you that if the court decide to find out whether you went to court in bad faith or in good faith, they can easily find out. I am not suggesting that if you lose the court case, it means that you went in bad faith. No. You can lose the case and they will know that you went in good faith. In fact, as a lawyer, I know that sometimes you even lose a case and your client congratulates you. He says, lawyer, I know you did your best, but it didn't work. He knows that you took the matter in good faith. But if you took the matter in bad faith, you must not only suffer heavy and punitive costs, in my view, you must also be restrained for holding public office for a while. Because you are undermining democracy. Because the issue of taking every matter to court perhaps is one of the reasons why people are losing confidence in the Electoral Commission. Undermining democracy should not be encouraged. Please, I'm a lawyer. If you have a case, go to court. If you don't have a case, don't go to court. Should I say it again, Dr. Farid? You agree with me, don't you? If you have a case, go to court. If you don't have a case, don't go to court. It's a simple matter. They say violence begets violence, and it should be completely taken out of our body politic. I'm of the view, respectfully, however, that violence is on the decrease rather than the increase. In fact, there was a time in this country where certain parties were so much in control of certain geographical locations in the country that other political parties could not enter. Both sides of the coin. And in 1992, I know that I went and campaigned in a particular part of the country and I was stoned, just for the reason that I belong to a particular political party. Today, there is no part of this country which is a stronghold for any party. They win the election, but it's not a stronghold enough for them to prevent somebody from going there. There's nothing wrong with you having a stronghold. It's a good thing. As a politician, you must work in your strongholds. But there's everything wrong with you encouraging your people to prevent somebody else from coming there. Whether it was direct encouragement or it was natural happening, I can't tell. But what I know is that from 92 to date, today, there is no part of the country that I cannot wear an NPP t-shirt and feel comfortable. There's no part of the country that I cannot go to, and when I say I'm looking for NPP people, some will not appear. We may lose in the place, but at least 2 or 3 people will appear and tell me that I'm an NPP. And also, I'm not sure that there's any part of the country that I'm not sure. I'm sure my friend Okujuta Black will advise us. But I'm not sure that there's any part of the country that NDC will go to and they won't get even one support. In fact, in the Ashanti region, their votes are increasing. Just as our votes are also increasing in the Volta region. It's a good thing for Ghana. You know, these people, they don't want to clap. I thought they would clap for that. But unfortunately, and it's important that state-sponsored violence should be condemned in no uncertain terms. I mean, it's just an election, you know. And what we must all learn is that the 4-year cycle comes very soon. It's an election. You win or you lose. And the 4-year cycle comes very fast. So we should not see it as do and die or do what it is. You know, Marita, I have great respect for you. But the die that you brought, do and do. There should be no die in this matter. We all want to live to see the glory of the Lord in 2024 and beyond. But there's a marked increase in disrespect for other candidates within the body politic. For some candidates, the way to the top is to destroy other candidates with lies and insults. This is inter-party as well as intra-party. It's not only between the two political parties. Even within political parties, it happens. People are creating monsters. It is alleged that they pay others to create lies about others, which they promote on social media and other platforms. The surprising thing is that when you confront the person, that why did you say this about me? You say, oh, Honorable, it's just politics. As if when it's politics, you must accept everything. Even though we have rules to deal with defamation, both under customary law and under common law, perhaps the time has come for us to craft rules to deal with misinformation in our political space, especially with the coming into being of artificial intelligence and social media and so on. Somebody can sit down somewhere and create something that we'll all be afraid of, a monster that we have not envisaged. So it's about time that we are talking about it, we start thinking ahead. And I'm not even talking about MDP, NDC, or A or B or C or D, but we know what artificial intelligence can do, and what a few people sitting in a room can create with a computer, or even now, even with their phone. One person sitting in his room with an iPhone, a good iPhone, he can create a lot of damage. Or a good Samsung as well, please. I'm not promoting. I have a Samsung and an iPhone, please. I'm not promoting anybody. You know, my friend there shouted Samsung because he didn't want me to use his platform to advertise for iPhone. Please, iPhone haven't given me any money. But closely related to lies and insults is the problem of making promises. In the desperate bid to get political power, be careful not to make promises. And this is my advice to all the people who are going to run this time. Be careful not to make promises. But the funny thing is that even when you haven't made a promise, the media will create a promise for you. Yes. My good friend Omar Osai created a promise for me that I said that within 2 months I'll build a skyscraper. I never said it. And he repeats the promise as if it's the truth, hoping that by lying constantly, the lie will become the truth. He's speaking after me, so I should be careful. Omar, I apologize. I was just joking. But the point is that I never made promises, but people were making promises for me unknown to me. There was a group of young men who sit under a shed constantly saying, and they are my people. When I pass, they give me all kinds of names. After one election, as I passed, I waved and they didn't wave back. So I cornered one of them in his house and said, what have I done to you? He said, you promised to do ABC. I said, I promised. He said, yes, you promised. I said, I came to say it. So your car was passing. And when we asked the man that will you do everything we said that you should do, but he said yes. And 1 year has passed, you haven't done it. The guy sitting in the party car had not even come to tell me that he had embarked on a voyage of promises for me without my authority. But even if he reported to me that he had made the following promises, I could follow up. But we must be careful about promises because it undermines the body politic. Promises undermine the body politic. This, unfortunately, is a rough and tumble of Ghanaian politics. Mr. Speaker, Mr. Moderator, another matter that should catch our attention is the question of vote buying. And I want us to look at it in the general framework of campaign financing. I want to look at it in a broader context. Because uncontrolled political fundraising and spending can undermine the democratic process and erode the confidence of the electorate in our political institutions. In Ghana, as well as in several places in the world, political expenditure has grown in recent times. Just take a look at the number of billboards and the size of the billboards, and you will agree with me that expenditure has increased. What should we do about this? Because campaign financing raises fundamental ethical questions for democratic regimes. Debates about campaign finances revolve around the protection of the freedom of expression. Some people argue that if I give money to Dr. Tamaklo, it's a form of freedom of expression. It is my money. I'm funding him because I believe in what he's going to do. Others say that it creates corruption. What should we do as a country? Maybe we should spend a little more time looking at the question of campaign financing. Can we limit the cost of campaigns by law? Can the state provide some basic funding? What punishment should be imposed on people who breach these campaign financing laws? Mr. Moderator, I've sought to raise humbly some issues and offer some solutions. But let me state once more that I'm of the firm view that our Constitution has served us well and will continue to serve us well. Our democracy is growing from strength to strength. Our elections are generally improving, and our judiciary is also growing from strength to strength. On this Constitutional Day, what can I say? That God bless our homeland, Ghana, and I'm happy and proud to be a Ghanaian.